We're really delighted today to welcome Gearóid Ó Cuinn, the Director of the Global Legal Action Network in Ireland. Gearóid was formerly a lecturer in public law at Lancaster University. His interests are in public law and global health, and he told us this morning that his doctoral studies were in pandemic governance. So those of you who may have questions that relate more to questions around COVID-19, I think you couldn't have a better person to answer them. Global Legal Action Network operates transnationally. It's an unusual human rights NGO organization in that it operates transnationally and in partnership with the Irish Centre for Human Rights in Galway. Given the fact that the Bonavero Institute is particularly interested in building links between scholarship and practice in the field of human rights, we're particularly delighted to welcome Gearóid, who has walked that walk for a while and does so in relation to his role at the Global Legal Action Network. Gearóid, we're going to turn over to you and your presentation. Thank you very much.
Great. Hello, everyone, and thanks very much to the Bonavero Institute for organising this webinar and to saving me from disposable travel. And a special thanks to Catherine O'Regan and Ekaterina Aristova for making this happen. So today I will be talking about the work of the Global Legal Action Network. We're an organisation that pursues legal actions across borders against powerful actors involved with human rights abuses and systemic injustice. And really the operative word here is border. This is what sets our work out apart from many other organisations. And it suggests that we are using legal systems and institutions in one country or jurisdiction to produce impacts or remedies in another. And that is very much the methodology of GLAN. But before getting into our work, I do think it's important to examine the terms we'll be using, specifically transnational public law litigation, and the origins of this young, exciting, and fast-changing field of practice. Because transnational litigation has its roots in the strong tradition of public law litigation. It's really where it emerged from. And the American context was very influential in the emergence of this field. And I suppose our work is very consistent with the latest iteration of transnational litigation, in that we are, I'll just change slides here, make sure I get this. Here we are. Our vision is justice beyond borders. We use the law to effect change across borders, and we tackle serious human rights abuses and systems that underpin them. So this is why I think we're consistent with this field. Just to give you some context and to show how recent a lot of these concepts are, strategic litigation or public law litigation was a term coined by Professor Abram Charles from Harvard Law School, and he was speaking about, or his definition of public law litigation was the practice of US lawyers to seek court-ordered decrees that reform legal rules, enforce existing laws, and articulate public norms. And from from the Second World War onwards, there has been a very strong institutionalization, I think, of public law practice in the US. It's something that has found its way, especially in legal education, where pro bono practice is seen as part and parcel of the education program. And this extended itself, this culture, it soon extended itself into the transnational sphere. And really this happened through the Alien Tort Statute of 1789, which is an obscure, relatively obscure piece of legislation that was enacted by the first Congress of the US in 1789 and signed into law by none other than George Washington. And the first Congress did this, and they included this peculiar piece of legislation because they wanted to ensure that lawsuits that involved international issues would be heard before experienced judges in federal court, and not in state-led courts that were could produce conflicting and confusing results. And they did this to prove to the rest of the world that they were, as a young country, a law-abiding state, fulfilling their obligations under international law. And this is where we get this very short, succinct wording from, this desire. The district court shall have original jurisdiction of any civil action by an alien for a tort or civil wrong committed in violation of the laws of nations or a treaty of the United States. So this law of nations being what we now call international law. So this meant that you had potentially had a cause of action in front of the federal courts. And really the first or the seminal case from a transnational litigation perspective is the Filartiga case, which has an incredible backstory. Filartiga was a young 17-year-old who was kidnapped and tortured by the police in the capital of Paraguay. And the story goes that after his family fled to the States, their lawyer was targeted as well. They sought asylum, and they spotted in Manhattan one day the police commissioner who was responsible for the torture and death of this 17-year-old. And this caused them to report this police officer to the immigration authorities. He was subsequently picked up by the police on a visa, for a visa violation. And then lawyers at the Center for Constitutional Rights deployed this really innovative argument using the Alien Tort Statute to argue that Pena, the police constable, should be liable for wrongs committed under the prohibition of torture. So this was a radical departure from everything that had gone before. Here we private individuals able to access courts in a separate country of which they were not citizens, opening up this transnational prospect. And soon afterwards, litigation confirmed in the Sosa and Alvarez Machen case of 2004 that violations of international law as developed over the previous 2 centuries could be actionable under the Alien Tort Statute. And this was a significant victory for the human rights movement because it made clear that other human rights cases could go forward in the federal courts. And while the original cases under the Alien Tort Statute were filed against individuals, from the 1990s onwards, we start to see multinational corporations increasingly brought to court for their complicity in human rights abuses. And up until that point, there was really a complete impunity for companies who were operating overseas in areas of the world where the rule of law was quite weak or the institutions unavailable to victims of the abuses they were involved with. So we can see that, you know, we're talking about a field that has emerged initially from a seminal case in the 80s, but only started to take off in the 90s and expand in the early 2000s. And from here, I think it would make sense for me to start talking about one of our own cases and to give you an idea of how our work fits with this. Here, I just want to introduce a person whose case we've been involved with, or our work has touched on, who is his name is Sukharat Saparov, who's a 29-year-old farmer from the Bruni district of Uzbekistan. And this person tried to hang himself in his barn for a very specific reason. He had lost the autonomy over his land. His land was confiscated because he planted melons instead of cotton. His case, and the case of many other farmers who were forced to grow and pick cotton, is quite shocking, given its scale. At one point, it was thought that up to a third of the Uzbek population would be mobilized into the fields. And this was state practice. It generated revenue for a clique. It's forced labor. It involved coercion and displacement because people had to be brought to various parts of Uzbekistan. And a classic example of the state abusing its own people. And it's important to understand how this form of abuse then interacts transnationally and with the economies of other countries that help sustain this system. Uzbek cotton accounts for more than 4% of cotton production worldwide. It is a brutal government-sponsored system that is at the very heart of its textile industry. And it means that doctors, civil servants, and others are forced to meet onerous quotas. And these are often enforced by threats of extreme physical violence or the removal of basic amenities, access to education and electricity and other such things. The Uzbek-German Forum has documented that about 400,000 people have been subjected to forced labor in their 2018 report. Their latest report is upcoming but delayed by COVID. People moved in long distances, and public sector employees tend to be the most vulnerable. Yet, despite these conditions, cotton flows freely into Europe, and we've been able to map the supply chains that sees this move unhindered across our economies for processing and for sale. And what's more, the EU has granted Uzbek textiles favorable import taxes in 2017, meaning that these and other goods produced through forced labor flow freely and are actually incentivized to flow freely through these borders. And this highlights, I think, how injustice, such as the instance of that farmer in Uzbekistan, his situation is underpinned by a greater structural injustice. And this is often the case with many systemic human rights issues that particularly affect the global south. And here we have powerful systems and actors that perpetuate these violations, which they themselves transcend borders through trade and their ability to prop up this system. And there's always a question about whether the law is capable of addressing such massive structures, because courts are limited by their jurisdictional reach. Oftentimes there isn't a suitable forum, never mind a suitable legal argument, a coherent legal argument that can be developed to tackle such great systems. And the access to the courts and the remedies available locally to the likes of Gearóid, whose situation I highlighted earlier, is practically non-existent. And this is where an organization like GLAN, that is set up to think and to develop and pursue actions in this transnational way, comes into play. And briefly, I just want to highlight our intervention in the space. We've launched legal proceedings in the UK to challenge the EU's trade measures that promote trade in Uzbek cotton. So we're arguing that the EU should not be incentivizing forced labor goods. And we argue that these trade measures are inconsistent with obligations found in international law, and therefore ought not to be applied and ought not to affect the decision to allow these imports to occur. And we've tailored our action to work with various coalitions and civil society actors who are trying to promote reform in the Uzbek cotton trade, because there have been some reforms, and we're at a crucial moment in EU-Uzbek relations when they're actually negotiating even more favorable trade regimes that would favor the further import of this cotton. So our timing was crucial here to hang over the specter of legal action. Having it hang over these negotiations was quite key. And we filed in November ahead of this engagement with the EU. And in this case, our partners were the Uzbek-German Forum, Anti-Slavery International and other NGOs, and we were able to instruct counsel and work closely with Bindmans and second one of our employees to avail of their systems expertise and insurance to bring such cases. And the end result is that we're aiming to reshape Europe's relationship with forced labor goods. And we try and use our comm strategies to maximum effect to ensure that the message can also gain political traction beyond the courtroom, beyond the process. Whether we'll be successful or not is difficult to know, but at least what this, we can build in interim wins that other NGOs and civil society actors can utilize. In April, we had a very interesting case kick off where we attempted to address the situation in Xinjiang province in eastern China, or where I think somewhere in the region of 1.3 million Uyghurs, a Muslim minority community, who are effectively subject to mass incarceration, and their mass incarceration is associated with a type of education program to break up their social fabric. Their children, after they're taken into these massive forced labor camps and facilities, are taken to boarding schools and orphanages for schooling in Chinese, through the Chinese language, and it's having a massive effect on their communities, and it is considered one of the largest mass incarcerations of an ethno-religious group since the Second World War. And the cotton trade in China is closely linked to this system. People are put to work picking cotton, processing cotton, and it is flowing again across borders into Europe through some major brands, including H&M, Moji, and others. And some of these companies, as a result of this pressure, changed their suppliers. We made a submission to the UK government arguing that the situation of the Uyghurs was of such a scale that the imports of cotton from this area violated an unused Foreign Prison-Made Goods Act of 1897. And we've submitted extensive evidence to them and pushed them for a decision, which could, down the line, trigger litigation. And again, we've worked closely with different coalitions to ensure this happens. So this is actually one area that we focus on. This is accountability in supply chains, an obvious transnational component. However, I should say that this example of challenging cotton points to how tailored our mandate is to tackle these quite widespread and far-reaching situations. And this speaks to how we've established GLAN to pursue legal actions that are innovative, that move across borders, and we select them on the basis that they're tackling power and addressing power asymmetries. And we do this by working with affected communities. So this is very much in terms of case selection. We try and figure out what strategies would materially benefit or impact the situation of an affected community. That's our compass. And to do this, then we work in partnership with various groups, some of which are international, some are diaspora or exile groups, others are expert NGOs on the ground where possible. And we have an extensive membership for 5 full-time staff with about 30 active members who are dispersed across our Legal Action Committee. So our Legal Action Committee is another innovative step. It allows us to bring together academics, practitioners, investigative journalists, and we think this is the tripartite that is necessary to really bring about effective transnational legal actions. And the last component, which I'd also highlight, is we've really worked hard to develop strong relationships with various law schools, which really boosts our capacity, but also introduces a whole new generation of lawyers into a different form of work. And as a recovering academic myself, I think this is a part of the motivation for establishing GLAN was to understand how academia and practice could better relate. There are tensions between the critical and practical approaches within law. And I found within academia, there is a tendency to, because of the lack of interface with practice, that there is a tendency to engage in extensive critique, but not offer the solutions of how we could reshape practice. The spaces just aren't there. In setting up GLAN and establishing it along with my colleague Yanis Kalpouzos, and who was a lecturer in City University, who's now lecturing over in Harvard, we were interested in setting up this practice but conscious of that it was a very unorthodox thing to do, and that we were providing an opportunity for international law activists or academics to bring their imagination and their know-how and to help it inform practice and improve it and innovate it. And this is really the space we were trying to create. So in addition to supply chains, we also work on other issues that have strong transnational features, such as war and occupation, environmental justice, and migration and border violence. So this is where we've directed our expertise and attention. just to give you a flavor of some of the other areas of work that we've been involved with, and again, to try and give you an insight into our methodology and how we design and keep strategic wins in mind beyond the yes or no of a courtroom. I think a very good example here would be our work on open source evidence and war crimes. This is a project that's led by one of our staff members, Dervin Minogue, and concentrates on the catastrophic humanitarian situation in Yemen. It was quite apparent early on with the airstrike campaign that the Saudi-led coalition were raining down on essential civilian infrastructure, that there was a real difficulty in challenging the sale of arms to the Saudi-led coalition. And this was because the evidence that was coming out of there was largely fragmented. There was no chain of custody. You were reliant on open source evidence, whose reliability is always open to question. And we were interested in working with NGOs on the ground who were really leading the way in trying to promote accountability for the grave civilian harm that was being wrought on the population of Yemen. So we worked with the likes of Mwatana, a leading Yemeni human rights organization as well, to figure out if there was ways in which we could address this, the transnational component, the arms sales that were facilitating and enabling the Saudis. And one of the first things we did was to bring together experts on Yemen, journalists and international law experts, to figure out how could we really revolutionize the evidence base from which we could attempt to litigate. How could we bring about the conditions for litigation? And I'm just going to try and show you a very quick video that will do a far better job of summarizing it than I can do in approximately 2 minutes. So let me just see if this will play. Okay, and I'll play here. And hopefully you'll be able to hear sound as well. So hopefully that gives you an idea of the types of networks we've been able to bring together to try and address this with Bellingcat, an investigative journalist platform, to really improve how open source evidence was being gathered and to work in really basic legal principles into the collection of this data so that it could produce investigations that would be far weightier and reliable in court. That was the goal. And that's on open source. And in addition to this, we're also working on direct evidence, as I mentioned, with the likes of Mwatana, who are on the ground. The actors who were able to bring together on that to field test our methodology, as the video indicated, those investigations are now published and are available on the Bellingcat website. And we hope that, we anticipate that further investigations will continue to be published on this. And again, underpinning all of that is our methodology that will ensure greater legal weight for this evidence. In addition to this, the result of this is that we're dealing with a torrent of information. So we've had to also come up with systems to enable NGOs on the ground who are under-resourced to be able to navigate and manage this as part of their legal accountability work. So we've been able to work with technologists to really improve how evidence is gathered, time-stamped using blockchain technologies, and then stored, so that we can say categorically that this man, before it gets to court, that granted it was taken from the internet, but since this time it has not been interfered with. It is completely faithful. And here we have an example of the digital evidence vault, a technology we've been Chrome extension that we've brought into our methodology that allows you in a single click to archive any online content, which of course could be taken down at a later point. And this has been brought on to the Uwazi platform, which is a system that allows you to navigate all of the evidence and tag it and sort it. And it means that you can bring direct evidence, open source evidence, reports, whatever you like, to bear on a particular airstrike. So not only are we changing how the evidence is gathered, we're changing how it's managed. And the airstrike database is available to our partners to help with legal accountability efforts. And we ourselves will be utilizing this, all of this evidence in our own litigation. So we're engaging in the entire life cycle of the information flow towards court. And we've already submitted, there has been a successful challenge that has suspended licensing to the Saudis, and they have to make a fresh decision. So we use this as an opportunity to get this information in front of them and provided them with unprecedented detail of the extensive violations of international law, the targeting of civilians, as have Bellingcat. They've been able to introduce this to the UK government. Which we hope will influence their future decisions on licensing. I'll mention also in terms of environmental and economic justice, really this is a huge priority for us. I think COVID has concentrated people's minds on the warnings that experts have been providing us, not only in public health, but also with regards to the climate emergency. And there is a sense that if we're not tackling this, we're rearranging the deck chairs on the Titanic, that we have to think about this great looming threat to the enjoyment and protection of human rights. And we've taken a twin track approach on this. We've prioritized our work around the stewardship of land with indigenous and local populations. We see this as the way to secure biodiversity, forest protection. We're currently working with, that image is from a airport development on the island of Barbuda, and we're assisting in the local community in resisting this land grab that occurred after Hurricane Irma. They came back to their island and discovered that their forest, which they'd held under common tenure since the end of slavery, had been confiscated. And we're working with them in a variety of different ways to tackle that. And again, climate change itself, moving beyond land stewardship, we are very much interested in tackling climate change head on. One of our more ambitious cases is the attempt to sue 30 plus European countries over climate change on behalf of 6 Portuguese children who are affected by the wildfires in Portugal in 2017. I'll talk a little bit more about this now, but we actually crowdfunded to enable ourselves to start bringing this case. And it followed on for some other climate change direct work, including the technical drafting of Ireland's fossil fuel divestment bill, which was a world first. We worked with a large coalition of organizations in Ireland to achieve that, providing a blueprint for other countries. And this has really spurred on our work on climate change. With the case we're bringing to the European Court of Human Rights, This focuses on, well, we hope to argue that any country that is contributing to the global warming that exceeds 1.5 degrees temperature, which is set by the Paris Agreement, risks the violation of the peaceful enjoyment of these children's rights and their possessions. And the youth applicants will argue that they're being unlawfully discriminated against as young people by the failure to properly tackle climate change by these countries. The Paris Agreement is of major importance, but it has some well-known weaknesses. It leaves to states to determine the amount by which they reduce their emissions to keep global warming to 1.5 degrees Celsius. And we see this weakness in how courts have responded when confronted with the claim that a government's emission cutting efforts are inadequate. Frequently, they've pointed to the absence of an internationally agreed target to uphold the lawfulness of government climate change policy. And our approach is to put to the fore the fact that these 30+ countries that we're suing are contributing in a material way to the threat that climate change poses. And we'll argue that the onus is therefore on those countries to demonstrate that their individual efforts are fair and adequate. And by putting the onus on those countries, we address a fundamental shortcoming of the framework created by the Paris Agreement, namely that it allows states to hide behind its loose definition of what amounts to an equitable contribution to the global effort to fight climate change. And I'll just show you a quick graph here showing where we are. We're currently at this point on in terms of global warming trajectory, and current pledges, policies, and even optimistic policies are setting us on a course that way outstrips the 1.5 degree threshold, which you can see here. And Europe itself, in targeting European countries, are very much failing to adopt policies that will see us meet that 1.5 degree threshold. And we know that Europe in particular is vulnerable to the fatal effects of climate change, as indicated by a 2017 Lancet study highlighting the consequences within the continent alone. So we think this provides really a powerful context for our case. And as I said, we're working with these Portuguese children who are actively engaging in advocacy, and we're hoping to empower them and their message, and work with a range of actors across the continent of Europe when we file this case this summer. And lastly, I'll finish up on migration and border violence, because I think this is an area that is very COVID sensitive. States have used COVID-19 as an opportunity to harden migration policies, resulting in extreme forms of violence and abuse against quite a vulnerable population. We have a variety of cases on this front. One of our first cases was thinking about how we intersect with the EU's contribution to human rights violations as part of its border externalization policy. This is a policy that's aimed at avoiding responsibility by the EU and its member states, and includes specifically its policies in the central Mediterranean, which require the collaboration between EU institutions, Italy on the one hand, and the Libyan authorities on the other, including the Libyan Coast Guard, which are ultimately derived from local militia. And we've sought to challenge and seek to address the dire human rights consequences that these policies are having. We frequently found that people who were returned to Libya through this EU externalization policy and securitization policy are sold into slavery, they endure torture, forced labor, or they disappear. So we're talking on the high end of seriousness when it comes to the abuses they endure. One of our first cases on this looked at Italy's coordination of the Libyan Coast Guard, focusing on a particular instance where 17 survivors of a fatal incident were able to bring a case before the European Court of Human Rights. On November 2017, the Libyan Coast Guard intervened intervened to try and pull them back to Libya. And I think about 20 of them died. And the vessel that the Libyan Coast Guard were using was donated by Italy. It was coordinated by the Libyan Air Force and the Maritime Rescue Center and Coordination Center in Rome. And it was a very good example of Italy trying to offset its responsibility. And we argue that because of the agreement with the Libyans, this engaged Italy's responsibility for the human rights issues that affected these migrants. I'm conscious of time. We worked very closely on this with forensic architecture and their project within forensic architecture known as forensic oceanography, which allowed us to take a previously invisible incident and to start to figure out how we could visualize it effectively. And they were able to construct let me see if I can fast forward this a little bit.
The vessel of the rescue NGO Sea-Watch was patrolling.
It doesn't seem I can fast forward, unfortunately. But
just outside of Libya's contiguous.
Yeah, I won't attempt this. We have a technical glitch here. But this is a forensic architecture. Or oceanography, we're able to construct a 3D model of the interaction, showing where the Italians were, showing where the Libyan Coast Guard were. And this provided an extremely powerful base from us to bring our case to the court, which was filed in 2018. And we're waiting to hear the result of that. And briefly, we've also been involved in the first submission on the issue of privatized pushbacks, where merchant ships are engaged. Because the NGOs have been pushed out, merchant ships are filling the vacuum, and the Italians are, on behalf of the EU, directing them to intercept and pull people back to Libya, where again, they suffer horrendous abuse. And we made a submission to the UN Human Rights Committee on this issue before December 2019, on behalf of a survivor of the Niven incident, which is where a car ferry was used to bring them back. And he was subsequently shot and held for 6 months, but eventually managed to escape. And lastly, sorry, my slides are jumping. We've also, in April, filed a complaint with the EU Court of Auditors, arguing that the EU is financially complicit in the abuses. That's a shot from our case page, which again, an extremely innovative argument led by our staff member, Valentina Azarova. And with all these cases, we have a very strong migration team with Itamar Mann, Violetta Moreno-Lax, and students from the Irish Centre for Human Rights who have supported this project. I just think I'll check in with time to see how, with the Bonavera Institute, to see if you'd like me to kind of wrap up around now and open up for questions and answers. Catherine, what would you prefer? But I could talk quickly about clinical partnerships if you like.
I think we'd like to hear about clinical partnerships, Gearóid. We've got some really interesting questions coming in from members of the audience, but perhaps you might just tell us a little bit about that, and then I'll put some of the questions to you. Thank you.
Sounds good. Yeah, so we've designed, as part of all of these projects, we've attempted, where possible, to engage with a variety of law schools in a number of jurisdictions, with the aim of supporting in a meaningful way our cases. So getting the students involved in the leading edge of these cases. And this has a twofold benefit. On the one hand, it provides us with capacity, and also some real treasure troves of expertise that students, especially at master's level, who have previous practical experience, that they can bring to bear in our cases. It also means that we're not taking volunteers in off the street. We're dealing with people who are already in the midst of their studies, and we try our best to bring the placement to them, which minimizes costs for them on their part. And they get meaningful practical experience as part of our cases. We work with approximately 13 to 14, I'm just highlighting some of them here, law schools. Some of them of the interactions are actually credited, so they form part of a module, as is the case with King's. In others, in the Irish Centre for Human Rights, we have a physical placement where we've allocated space, and we bring together anywhere between 10 to 13 students each year to work across a variety of cases, and we have weekly supervision, which is really quick fire. Being in together with them in the same space is a real accelerant. And then we've other remote interactions with universities on the continent, including University of Amsterdam and others in the US. And the US really can bring an awful lot of resources to bear. Stanford, for example, supported the gathering of evidence for our complaint against Australia in our submission to the International Criminal Court for their treatment of migrants in offshore detention facilities. And that case benefited from the academic input of Yanis Kalpouzos and Itamar Mann on banal forms of crimes against humanity. So we were able to sync up a very strong connection with academic work, the clinics, and engage with practitioners at Stanford as well. We were able to lead that. It was Diala Shamas who made that submission. So each interaction is very different. And I think this also points to in transnational litigation generally, there is no best practice. You learn through experience. In each of the cases I've shown you, you've had different degrees of engagement with a victim, or sometimes there's no victim at all. You're dealing with an NGO that's representing victims who can't speak out, whose situation and security situation may not allow them to. So there's various trial and error, and we're learning an awful lot. And I'd be happy to speak more about that in questions and answers. And just a little word on our networks. In addition to law schools, we interact with firms. They provide us a lot of know-how internally to run as an organization. We find they conflict out a lot, especially on questions of international business. Even if it's on stuff like slave labor in North Korea, you'll have law firms conflict out on that. But they would help internally, risk assessments. We're conscious of SLAPP injunctions. It's a tricky environment. Ngo Partners, as I've mentioned, we're working with a variety of NGO partners across a range of issues, from Amnesty International right down to grassroots organizations. And pro bono clearinghouses have been excellent. We've had a strong relationship with Advocates for International Development, PILNet as well, and it allows us to put out questions in really niche areas of law and access expertise quite quickly on a pro bono basis, and that really supports our work and enables us to punch above our weight. And then just to quickly reflect, the take home from the transnational litigation experience is, in confronting the human rights issues, we have to pay attention to the political and economic arrangements that create them. And in some legal actions, we may only focus on the symptoms, these particular human rights abuses, and it could be that in our advocacy we get to focus on the structures. And sometimes it's the opposite, but we try to make sure that dual approach is there. And this is really learning from the lessons of the public law litigation in the US, which was very lawyer-led initially, and has now really moved towards impact litigation that engaging with communities. And this is the distance issue with transnational lawyering is a problem. We have to try very hard in building relationships, building trust across borders, and to avoid us being neo-colonial and to avoid us being a lawyer-led organization that can show, look, here's my fancy legal acrobatics, but what actual impact have I generated for the affected community? So I think that is the real measure of success, is how we understand the impact on the ground. Failing to take into account structural inequalities and economic conditions that create vulnerability to repression makes it hard to progress past your client's suffering. Again, I think I'm reiterating the structural dimensions of our work. And the other thing that can also get lost is the time and the effort in ensuring a comprehensive understanding of the affected community situation. The narrative, the storytelling is very important. It cannot just be a dry legal set of communications. And I've seen other transnational litigation organizations like the European Centre for Constitutional Human Rights do a great job on really bringing to the fore the narrative, the human dimension of all of this. That should not be lost and should be at the forefront of everything. And we try to push it to the forefront of everything we do. And one of the areas that we're constantly dealing with is measuring impact. It's a very difficult field to measure impact. It is built upon the presumption that law leads to change. It is a lever of social change, but you have to be very creative in diversifying the ways in which you measure impact, from the victim level to community level to social, to changes in discourse, to an awful lot of non-legal indicators to help you understand whether or not you're having concrete results. And I think I'll leave it at that, and happy to take any questions.
Thanks very much, Gearóid. That was really interesting, and it sounds like very interesting work. And we do have a range of really good questions from our audience. So one of them is about how you identify what cases to take, how cases reach you, and how you make an assessment of the merits of a case that comes to you. So maybe you could just talk a little bit about that, how you identify cases, how people get to you, and how you assess whether it's an appropriate case to take.
Yes, a great question. Part of our design, as I mentioned before, with this legal action committee, was to have an extended community of experts who understand and are in touch with organizations on the ground in areas where grave human rights abuses are occurring. So conversations amongst our membership was an initial starting point when we first commenced our work. And secondly, watching what was emerging from news sources, understanding like emerging situations that required some rapid reaction, or or even prolonged situations that could have benefited from a legal intervention, were brought to the table, and we would incubate, go through a period where we discuss and eliminate different options. And with all situations, we would come with a quite modest, I suppose, posture. We would try and communicating with communities on the ground, we would never suggest that law is a silver bullet, but it may nudge things, it may support their pre-existing justice strategies. So when we were designing and selecting our cases, we would keep that in mind, that we were trying to merely assist other political actors and activists who were seeking justice or reform. And that meant that our selection was based, we could be a bit more creative. We could go for cases where we would have success without legal victory. And we would talk with the local communities to see, is this something that would help you? For example, in Bahrain, we were looking at how the hospital system was being used as a surveillance tool. If an injured protester was brought in, they were immediately rounded up, tortured, and imprisoned. And we looked at how Irish medical degrees were being awarded in those same spaces because of transnational education. And we were seeking to have the Irish degree awarding capabilities removed as a result of this overlap. And we had to check with doctors, is this something you want? Will this impact your situation negatively? But the resounding answer was, no, we want this because the situation is so dire. Having the Irish education standards removed wouldn't really change things, and the attention could benefit us. So that's how we'd assess it with local communities. And impact, we try to make sure that we're achieving low cost, high impact cases wherever we can to enable things to move along, because otherwise engaging in long-term costly litigation can have very negative effects for relationships with NGOs. And as our organization matured, I think our conversation with our relationships with NGOs on the ground has really strengthened, and those conversations produce all sorts of interesting ideas. And now we're being approached with ideas from the various networks and coalitions that we've been able to work with. So that means we've got a steady flow of cases, and we make critical assessments on whether we can improve the situation as I've just described.
Thank you. I think for this question and answer session might be a good idea if you stop sharing your screen, and then people will be able to see you more clearly on their devices.
Sure.
One of the questions asked by my colleague Katja Aristova is the question about what you see as the real barriers to transnational litigation that you face. So funding, questions of access to evidence, and I might supplement worries about cost orders, managing in very different jurisdictional settings.
Yes, funding is definitely a tricky issue. I think there has been a shift, though, amongst funders, an increasing appreciation of the power of innovative legal strategies. That you're not just funding a bunch of well-heeled lawyers, that you are actually engaging in a broader justice initiative. And I think that engagement with funders is critical. And again, I re-emphasize the importance of bringing the voice of the affected community in, because that's the hook. That's the motivation for our angle, for our actions. And it is something that I think would resonate with funders when they see how legal action can support communities who are otherwise struggling and isolated. So that funding is definitely an issue, and we are exploring different funding models. And as you've seen, we've engaged with crowdfunding, which can be, it's resource intensive. We've tended to approach this through project-based funding requests to private grant donors. And we found this as the best key to unlocking this form of practice. And then now that we've got a track record, we're moving towards core funding. And you know, the Jaffe Trust have been very generous with us. They've just provided us with a full-time administrator for 2 years, which will really open up free our time from fundraising to focus a little bit more on the actions themselves. The other obstacles, I think, is that we face regularly are communicating effectively with people on the ground and ensuring that they understand and appreciate their role, their centrality to the process, and making sure that while we are in isolation from them, that we don't get lost in the legal woods, and that we remain faithful to their message and their involvement. So really pushing for meaningful engagement has been a challenge. And then lastly, I think the other thing I'd highlight are the institutional costs. We're learning ways of different configurations of working with firms to see if we can benefit from their resources, you know, their expertise, as I mentioned already, things like insurance. And we're learning to deal with risk a little bit better. And this is where a board of trustees has been critical. Bringing in non-lawyers has been transformational, because they're less A-typey and territorial and have experience in organizing and building. And they've helped us with you know, really tailored systems for managing risk. And the risks include, you know, counter litigation such as the False Claims Act in federal court in the US, and slap injunctions, and negative unanticipated risks associated with the type of work we're engaged with.
So another questioner has asked whether you see a risk in transnational litigation as becoming a target of populist political elites on the basis that it's kind of illegitimate foreign courts that don't have democratic authorization making decisions, etc. And is that kind of line of argument something you think about and worry about, that sort of delegitimization, as it were, of kind of human rights litigation for those kind of on the basis of those kind of arguments?
Yes, and I think early litigation efforts, they were very valid critiques, and I think there's an awful lot been learned about how, and this is the advantage of bringing in academia, as I mentioned earlier, that frustration with the frustration of law, bringing critique into our work and operating reflexively has been part of our methodology, and we've tried to build it into our standard operating procedures to ensure that we're not operating neo-colonially. And we can really see this, especially when it comes to documentation and truth-telling and fact-finding, and that you push up against these populist currents. You see that, and it's a definite challenge. I think part of our strategy as well is, and this comes back to how we position ourselves within the legal actions. We often will try and take a backseat role and bring the local NGO to the fore, both in design and communication. And that is a very good lens through which to move everything. It forces us to just really be conscious and self-conscious of our own position, because they are valid critiques if you're not behaving in that way. But I do think that our work speaks for ourselves, and that we are tackling the centers of power. And moreover, in terms of legitimacy, which I think is a great question, we are ultimately addressing how our economies, political order, and legal systems are either turning a blind eye omitting to act are actively involved in various human rights issues in the global south. So we are tackling a strand or a lifeline or driver of those human rights abuses. And that is a legitimator, I feel. It's also getting our own systems and social orders in check. You're muted, Catherine, I think.
Thank you. That leads to another question that one of our questioners has put, and that's the problem for lawyers and human rights organizations in the global south, where very often there are shorter funds, it's very difficult to bring litigation, and the questioner speaks particularly of the situation in Ecuador, where it's been very difficult to continue a struggle against the company Chevron Texaco, and many environmental lawyers are unemployed. I mean, is there anything that an organization like GLAN can do to support litigation and lawyers in the global south and human rights organizations?
Yes, I think it's somewhat limited because of our own limitations and capacity. I think there are ways in which we can benefit from our institutional affiliations. So by working with universities and connecting local actors to those universities, that can often be a way to assist them in either further education. We've worked with the Irish Centre for Human Rights. We've had the benefit of working with an awful lot of students from the global south, and having their expertise and promoting their, I suppose, professional development. But in a material sense, I think it's a really good question. I think it's about ensuring that when you fundraise for a particular case, that you build in the costs needed at the local level. And I think that will be a product of the maturity of an organization. Once you get past that startup phase and you have a certain amount of liquidity, you have capacity to start, saying, okay, look, let's not get funds for us. Let's include the actors in the global south. And we have attempted this, and not always successfully, especially in the situation of Yemen, of making sure that we try and, where possible, actively incorporate the views of the local actors into the full range of the life cycle of the case, from funding upwards, design and implementation, right through to communications. But yeah, I like the legal actions. I think we have to be modest and underestimate what we can do, because I think the other thing we have to avoid is creating false expectations.
Yeah, thank you. Now, one of the other questions has directed particularly at the case you mentioned about the climate change case on behalf of the Portuguese children and in the context of the mass fires in Portugal. The questioner wanted to know which court you're going to litigate in, where you're bringing the case, so that, and to the extent that you're not bringing it in Portugal, whether there are issues around the exhaustion of local or domestic remedies.
Yes, it's to the European Court of Human Rights in the Strasbourg court. The issue of the exhaustion of local domestic remedies is predicated on the nature of our applicants. These are young people whose lives are already impacted by climate change, and they're being impacted by the failure of other states to sufficiently reduce their greenhouse gas emissions. And the practicality of these children being able to assert their rights under the convention in these various countries is practically non-existent. And it's through this, through the sheer scale of both the problem and the number of countries that we're tackling, that we think will help us address that admissibility hurdle. We also anticipate that by taking it against multiple jurisdictions, it also provides a unique moment, a political moment for civil society actors who are active on this issue, especially after COVID, who are pushing for a sort of just transition out of this pandemic, to mobilize their message and to point that, look, we really need to pay heed to the curves and bend the curve of climate. We really need to imagine how we can lock in some of the advantages gained by the lockdown and move forward in a just manner to tackle climate change in a really meaningful manner, because we're not on track. And being able to do that across multiple languages and jurisdictions, we think will also be powerful, in addition to the actual filing of the case during the summertime.
Yeah. So another questioner has asked the question about the relationship between transnational judicial dialogue and transnational litigation, and whether you think that the sort of much discussed increase in practice of judges across jurisdictions meeting and talking to one another on a range of topics. I mean, human rights being one of them, but also on how to deal with asset forfeiture and money laundering and intellectual property. I mean, judges meet and talk about a whole range of common problems. Do you think that kind of dialogue has an impact on the litigation or the outcome of the litigation, or was that very speculative?
Yeah, it's difficult to say. I think those areas you identified, I think you're 100% correct. There is so much technical cooperation across jurisdictions, especially on economic offences and financial crimes. And this is where I think human rights litigation could actually piggyback, where these types of tools could be used for strategic impact proceeds of crime. We're actively engaging in 2 or 3 cases now that blend money laundering and proceeds of crime as the core vehicle for our addressing human rights violations in a number of different countries, including Western Sahara and others. And on the judicial element, I can't really say, because I think it's an area that human rights litigators have slightly neglected. It's not an area that they actively pay attention to, and perhaps to their own detriment. And it could be that this should be, and I know some organizations have, certainly in the US, they pay a little bit more attention to this. This could actually be another way of in addition to showcasing this type of work, is to engage in sort of a legal education program in highlighting the developments that are occurring at a really amazing pace across a number of jurisdictions, and understanding how they could inform the domestic practice of other judges and their legal standards. But yeah, I don't want to go on about that, because I really feel I'd be out of my water in commenting on judicial interaction.
Okay, and then to go back just briefly to climate change, again, my colleague Katja has asked the question about the fact that there's been quite a trend in the United States in climate change litigation to bring litigation against corporates that are perceived to be in one way or another driving climate change, but that we haven't seen that in the UK, and whether you have got any thoughts about why that might be, and whether you see that there's any possibilities around bringing climate change lawsuits against business in the UK or jurisdictions other than in the United States.
Certainly, yeah. I think, there have been certain slightly more innovative approaches, not classical court-based litigation that has already taken off. I think client earth are really leading the way on this. Just recently, for example, BP attempted to have launched this green advertising campaign where the color tones and the claims they were making, trying to brand themselves as a progressive climate change conscious organization, were completely rubbished by a submission to the UK's NCP, National Contact Point, on the OECD mechanisms. I think Tim Cook-Earl was part of that challenge, and they essentially pointed that the minuscule percentage that BP was investing in renewables compared to their carbon heavy footprinted work in the oil and gas sector meant that the claims they were making were actually misleading to consumers, and they took a consumer-based approach to that. And soon after, BP pulled their entire advertising campaign. So we're starting to see the dawn, I think, the door being cracked open there into all sorts of really creative ways in which corporations could be challenged. And I think it's ripe for the taking. I think this is an area where we should be focusing our minds, developing legal strategies and executing. So I definitely think there's an opportunity here, not just in the UK, but in Ireland and other European countries to, again, really concentrate efforts. And that's the other dimension of what we found with our work is our mandate has allowed us to sit patiently to think through and concoct some strategies that if we were focused on a single issue domestically, we might never have had the time because of we've relieved ourselves of domestic practice with domestic victims, I should say, we have this opportunity to bring take a networked approach to these questions.
And then there are a series of questions which relate to China and its human rights practices or failure to practice human rights. One of them is the question around, you talked in relation to your supply chain around the use of forced labor and Uyghur communities who are in forced labor camps in relation to the production of cotton in China. And the questioner wondered whether there are any international law, is there any international basis upon which those practices could effectively be challenged? I'm sure this is something you are thinking about.
It is, and they're correct. In the instance that the grounds that we highlighted, the bases on which we felt that the imports of this cotton from Xinjiang province should be halted was under the 19th century piece of legislation, but also proceeds of crime. And there is the potential that what's happening in Xinjiang province and to the Uyghur community more generally could be considered a crime against humanity. And this would have very interesting domestic consequences if that classification took hold, be it in international legal opinion or in some international forum. It would open up all sorts of very interesting domestic opportunities to tackle complicity in the forced labor of Uyghurs and non-Uyghurs too. So, but it's still at a quite molten early phase, and the roundup of this community really commenced in earnest, I think, at the end of 2017. So I think that the legal response is always a slight lag, and we'll start to see this momentum build around these questions. And in the case of Yemen, I think if you look at the work of global rights compliance, they've done some great work around the question of starvation in Yemen, and looking at, instead of looking at airstrikes and being fetishizing technology, they've been looking at the overall impact from the civilian perspective and articulating starvation as a war crime, and have been indeed active in reshaping the Rome Statute on that front. So I think the same will happen when it comes to the Chinese context.
Yeah. So, and another question which relates to China, but in fact has a resonance in many places around the world, is the connection between censorship and, as it were, impunity for human rights violations. The extent to which, if a state censors publication of information around human rights violations, that undermines the ability to address them. And whether you've thought about those issues and whether you'd like to kind of discuss how one might address that kind of a problem.
Yeah, you're really, and this again points to the how unsatisfactory sometimes transnational litigation can be, and that you are up against a monolith in terms of being able to freely communicate these ideas internally within China. The chance of them securing political traction is limited, but as a member of the international community, China isn't completely, it is sensitive to the accusations laid against them. They spend a lot of time trying to deal with them, and it does shape. Evidence suggests that these campaigns can shape behavior, and we are relying on that, unfortunately, because the censorship is so heavy. And there's the issue of, if you tried to communicate domestically with people on the ground, are you endangering them? That's the other flip side of this, that you're an active driver of risk by engaging with local populations. And we've had to spend an awful lot of time thinking about security. We've had past members whose WhatsApp has been hacked, and leading to a patch issued by WhatsApp. We've been at coalition calls where the coalition call will just, or the webinar will just abruptly halt, and evidence would suggest it's been hacked afterwards. So there is a transnational reach to that censorship, albeit quite minuscule compared to what you'd see on the ground.
Yeah. And then turning to your kind of pandemic governance expertise, one of the questions that's come in is whether there is a basis for holding China accountable for its failure, so the questioner says, to properly inform the world about the effective nature of COVID-19, and obviously with the consequences that has led to. Any thoughts on that?
None in particular. It's not an area that I've actively researched. Looking at past epidemics, typically what happens is the serum testing, there will be a way for mathematical modelers and epidemiologists to reverse engineer and figure out the true extent of the pandemic at a particular time. And the international health regulations which govern this area and international cooperation and information sharing have actually already been adapted to China's intransigence and its failure to promptly notify and share information. So this means that online sources are a valid form of information for producing an international response. You're not waiting for the Chinese authorities to formally notify through the requisite routes to the WHO that something's wrong. But it's with the degree of censorship, as raised in the previous question, whether or not those systems are sensitive enough to detect in a timely manner the emergence of a new virus is really open to question. And I'm not sure what role litigation will play in this or what likelihood of success would be, because ultimately this system is a product of international cooperation. And it will be about applying the right type of political pressure to ensure the right epidemiological and public health gain, is my sense. But I haven't really put much thought into the prospects for litigation, although I have seen some very clever articles on Opinion Jurist that have addressed this issue, which suggests that certainly at a US domestic level, those prospects don't exist.
Yeah, interesting. So another questioner has asked whether there are any successful prosecutions of kind of war crimes or crimes against humanity that you'd like to refer to, that you think that, so this is really, looking at international prosecutions that you think are good examples of international law holding people who have perpetrated war crimes to account.
I think, looking at the ICC, it comes with its own baggage and unsatisfactory processes and outcomes. What really has piqued my interest, though, is the role of the reemergence of universal jurisdiction practice across, especially in continental Europe, in the aftermath of the Syrian conflict. And there has been an attempt to create a joined-up strategic approach to addressing the immunity of people who've been involved in human rights abuses and war crimes and who have fled into Europe, and showing that their accountability extends into this space. And I think there's been a number of attempts in Sweden, in Germany, and this it seems to be gathering momentum, and a lot of this has been spearheaded by the European Centre for Constitution and Human Rights in Berlin. In terms of good examples, again, one of the issues or the fault lines in this question is when you're tackling a particular individual, you are not addressing the source of the system that's producing the underlying crimes. There's a certain political, in the Syrian context, for example, there has been a certain political rehabilitation of the Assad regime in certain quarters, meaning that while you will get this piecemeal approach at a universal jurisdiction level, the perpetrators writ large, who are at the top of the command chain, are sitting quite comfortably. And I think it has to, and this is where the strategic joined up thinking that I was talking about that's emerging now is really seeking to address those shortcomings. For our own purposes, we have been looking at using private prosecutions, especially in Ireland, where it hasn't been tested as much. And Ireland as a global economy does attract some interesting and questionable characters. And we did try to have Bahrain's Attorney General arrested when he attended a conference of the International Association of Prosecutors, would you believe, a standard-setting body in good practice for prosecutions, of which he was vice president. It was like a cruel joke. And we sought to have him prosecuted. We flew in a torture victim from who had asylum in London, who detailed some horrific torture, and we even found documentation of the Attorney General being warned he would be tortured if he wasn't released, and he was held incommunicado for 90 days and made stand 23 of those. And again, the court failed to act, and we couldn't take any follow-up action because we weren't sure whether or not he landed or not. We couldn't confirm, and we needed to have him in the country before we could take on a complaint, maybe to the Committee Against Torture or otherwise. So you can string out this process and figure out other ways if the court fails. But at the very least, I think all of these efforts do point to is the failure of countries and courts to really live up to their obligations as third states and to take seriously the question of universal jurisdiction. And that should be, I think, a part of a joined-up advocacy campaign and political campaign to address these systemic shortcomings.
I mean, it was very interesting that just in the last couple of days, we've seen the arrest in France of a very high-profile alleged funder of the Rwandan genocide, Félicien Kabuga, and that's 26 years since the genocide. So one does have a sense that there remains a commitment in some quarters to trying to hold people to account. But I think that the process establishing criminal liability across borders and with many different witnesses is a very challenging legal exercise. And that's unlikely to change because we want to hold on to principles of, people being presumed innocent, etc. So it's particularly hard law. Well, I think that covers pretty well all the questions that have come in, and I would very much like to thank you, Gearóid, for a really fascinating conversation and fascinating presentation on the work that GLAN is doing, and to wish you and your colleagues well with the work going ahead. I'm just seeing if there's another question that's come there. Yeah, it's back to the difficult question, which I know that you said you hadn't thought about to an extent, about China and liability for COVID-19. And perhaps I think we have covered that. So I just wanted to thank you very much and to wish you and your colleagues well with the work, and look forward to having more engagement with you in the years and months ahead. And also to thank all the people who've participated today. It's been great to have you with us. This is the last of this term's Bonavero discussion groups. We have a full schedule for next term. We may well be hosting a range of other discussion groups, however, over the summer. So keep an eye on our website. We will keep you informed of that. And we wish you all, in the meantime, good health and safety to you and your families. And look forward to welcoming you to a Bonavero event again soon. And thanks to the Bonavero technical team of Christos and Gayatri for their usual efficient managing of it. And a final thanks again to you, Gearóid. It's been great to meet you.
Thanks so much.
Bye now.
Bye-bye.